Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live. My name is Robert Gouveia. I am a criminal defense attorney at the R&R Law Group in the always beautiful and sunny Scottsdale, Arizona. And today, my friends, we have some serious business to get into. And we're going to start today by taking a look at what's been happening with the Donald Trump FBI Mar-a-Lago saga. And a big story came out from Just the News. There's a guy over there named John Solomon. And we're learning a lot more about the Biden administration and their involvement in the FBI raid of the president's home at Mar-a-Lago. And so specifically, we're going to look at a couple different things. First, there's a letter that came out from NARA, the National Archives, and we got the full text of it. This was a letter that was actually drafted back in May of this year. And it details sort of how this whole chain broke down. And so we're going to go through that. And I actually created some structure for us here. You see this one, we've got this structure, sort of 10 steps, I'm calling it. The 10 steps to indicting Donald Trump. And we'll go through all of those 10 steps. We're at right now at about step 7. And so, they're doing a step 8 discovery review. Then we're going to get into the grand jury and probably an indictment sooner rather than later. So we'll get into that all, of course. And then we'll check in with John Solomon. He had on his show Representative Jim Jordan, who was, responding to a lot of this. Now, we've already all known this, right? Obviously, Joe Biden's behind all of this. What do you think? Like Joe Biden? No. Trump? Investigation? What are you talking about? Of course he's behind it. We're just now putting evidence together and putting the pieces where they belong. Then we're going to take a look at Donald Trump and the actual litigation taking place in the search warrant case. We've got a new order that came out from the court yesterday. And yesterday on the program, we were live a little bit early, and so we didn't catch this one. But we did catch the new lawsuit. So Trump is suing the government. We're also going to take a look at that. That's in this docket entry, Trump versus United States. So we'll get there. But we've also got the search warrant docket, and there was an order that came out that is actually pretty good. So we're going to go through this one. The judge is making his finding. He's saying, listen, we are now ruling that you cannot have the entire affidavit sealed. Okay, like something is coming out. And so he actually issued an order on that late yesterday. We're going to read through it. We're also going to see that the Gang of 8, they want access to all of this. Did V says it's not streaming there? Why is it not streaming over on Rumble? What on earth? It's like one or the other. What the heck? Let me see if I can fix that real quick. I don't think I can, though. All right, we'll have to do that. I don't know what's going on. Sorry, Rumble, if it's not working over there. It's like one or the other. It's like I can't get them both working. All right, so we are going to get to that. Donald Trump and the search warrant docket, the Gang of 8, bunch of Republicans and Democrats who are so-called intelligent Congresspeople. They're going to want access to the affidavit, and we'll see what their argument is. And then Steve Bannon. We've got a new motion from the Bannon case. Remember, we covered that trial, if you want to call it that. And Steve Bannon filed a new motion that we will take a look at, and it is a doozy, right? It's a mouthful. Let's take a look at this. You can just see here. Look at this. Look at the language on this. Defendants reply to the government's response to the supplemental brief in support of the motion to exclude congressional evidence or to dismiss the indictment based on granting the motion to quash and congressional subpoena recipients' refusal to testify or to produce documents. Whew! It's a mouthful. So we'll unpack what's going on there, but he filed that. He's hoping to get a new trial. And then Bannon also, he came out and he gave a little warning to Merrick Garland. He said, Merrick, you're not going to be in charge forever. The Republicans will be back. And when they're back, they're not going to be happy with you. And so he's warning them that there may actually be, prison coming for people like Merrick Garland and others who are, wrecking America. And so we'll go through that. And then we've got this new poll that came out. Look at this one. This is fun. If Liz Cheney runs for president, well, Donald Trump might actually have a better shot at winning the presidency because she might actually peel off more support from Biden than she would from Trump. And so, my friends, my goodness, look at all this stuff. We got a lot to get to. And if you want to be a part of the program, the best place to do that is over at watchingthewatchers.locals.com, and they are chatting away over there, and I'm not real sure What the heck is going on? Why Rumble's not working? John McGarvey's over there on Locals. Savvy Sue, Zach Nichols, Phantasmagloria, Kelly Sell Now. Paul Minot is giving away memberships over on YouTube. And Paul Minot, I saw joined over on Locals as well. So shout out to Paul. We're glad that you're here. And speaking of Paul, I wanted to share this. Look what Paul said. He sent this in as a super chat before the show got started. He said, "This is in honor of BC artist Lucinda Turner. Her family took me in and changed my life. Says, a fighter for justice and one of the best friends I ever had. She never gave up. I love you. Wait for me at the gate." And that's just a beautiful message for Lucinda Turner. I was able to pull up a photo of her here, and you can see beautiful woman. Here's a piece of her artwork. Pictured here, Shaman in Trance, 1992. Died earlier this week. And so shout out to our friend Lucinda Turner and our friend Paul Minot, who is very generous. And in honor of artist Lucinda Turner, gifted 20 memberships to our community. And so cheers to Lucinda, my friends. And thank you, Paul. You know, I have friends like that in my life. Not many of them. One or two gentlemen, two of them, and they're still here with me. But I know how impactful they are. And so cheers to Lucinda. Thank you for changing Paul's life for the better. Cheers. All right. And thank you, Paul, for that. All right. So now let's get into some other business, right? If you want to be a part of the show, YouTube is a place to be. Shout out to our mods playing hookies over there. Lean, Just Cause. I saw Vienticus earlier. And we also have a law firm, the R&R Law Group, 480-787-0394. Anytime anybody you know is charged with a crime in the state of Arizona, traffic violations, all the way up to serious felony offenses, we would love the opportunity to help. We are very passionate about this. I had 2 great meetings with my team this morning, and we're rocking and rolling. So we'd love the opportunity to help. If you happen to know anybody that needs an amazing legal team, that is us. I appreciate you sending them our way. All right. And so let's get this bad boy queued up here so we can just get into the program already. And, you know, we're learning something that we already really knew. Joe Biden, it turns out, sort of knew a little bit more than maybe he let on. Knew exactly what was going on with Donald Trump. He was sort of instrumental in the plan. We're going to go through this today, but we have a new article that was released over from a website called Just the News. And here's what they are reporting. They say this from this quick snippet, and we're going to read the actual letter in itself, but it says this. It says, long before it professed no prior knowledge of the raid on Donald Trump's home, the Biden White House worked directly with the Justice Department and the National Archives to instigate the criminal probe into alleged mishandling of documents, allowing the FBI to review evidence retrieved from Mar-a-Lago this spring, eliminating the president's claims to executive privilege, according to a new letter to contemporaneous government documents reviewed by Just the News. And so this came over from this fella. His name is John Solomon, and he gives us a lot more details on this. But I want to sort of make sure we understand the structure of how this works. And so what I did is I detailed this out into 10 simple steps to indicting the former president. And here you can see they are detailed for us. Step 1. Well, we're going to start here. And so this is where we're talking about Biden waiving privilege and sort of opening the floodgates against Trump. So we're going to come back to that. But let's work backwards a little bit. So remember, the Democrats and what many of the anti-Trumpers really ultimately want is they want an indictment. They want to get there any way they can. And some potential opportunities for indictments, we've talked about many of these here. Records requests, Espionage Act, presidential records, PRA. We talked about that. We also talked about process crimes, saying that Trump was supposed to deliver something. He said that I did deliver it. He didn't deliver it. So he lied to an FBI agent about what he had or what he delivered. Process crime or obstruction. We've demanded this. We've gotten subpoenas. We've asked you to do all of this and you're obstructing. Just different types of indictments, right? Different types of criminal allegations that could potentially be brought. Got that. Well, how do you get to an indictment? Well, you got to have a grand jury, right? You got to present this. Donald Trump's a monster and an orange Cheeto. Do you hate him? Yeah, we do. Great. He's indicted. Now, here we're sort of lingering around this process, right? The FBI has already gone through step 6. They've already gone through step 7. They got the warrant. They claimed that there was some urgency to the warrant, but I still don't really know why that is a justified argument. As we know, They waited 18 months, more or less, until they actually got the documents back. So they were okay sitting in Trump's closet for a while. Then when they signed the warrant, when they actually got the judge to basically authorize it, Garland waited weeks contemplating whether or not to move forward with it. Then once it was capable of being executed, meaning the judge signed off on this, so Garland, should we get it? Yes, we got it. Should we do it? Yes, we did. After they finally get it on August 5th, they wait until August 8th to go and actually execute the warrant. Why? Because they wanted to conveniently wait until Trump was gone. So we've got sort of the structure there. Then they went to raid the materials, to obtain the materials. We know that there was basically no particularity in the actual warrant itself. As you can see, one big line item here saying we want any governmental presidential record, any record created between January 2017 and January 2021. Okay, so the entire presidency, any record. That is not any particularity at all in that warrant. And so it's offensive and disgusting. It was also overbroad, right? They captured their passports and so on and so forth. But we got to work our way back up the chain. How did all this start? Like, where did they get the basis for this? Well, they say they issued a subpoena. We've actually read about these communications back and forth. Trump, according to his lawsuit, said that when the FBI came poking around Mar-a-Lago, he invited them in. In fact, he stopped by the conference room and he said, hey guys, how are you? Anything you need, you let us know, right? We talked about that yesterday, and that's been reported and corroborated by multiple people. And so as we continue to work our way backwards, we have to sort of start to see now how this all emanates. And watch, as the letter is going to detail, we keep reversing into the parking space, and we're going to see that somehow NARA started working with the DOJ. The National Archives started working with the DOJ, right? It became a records and overdue library books matter. Then it became a criminal investigation. How'd that happen? We got to connect those dots. But before that, NARA has to say there's a problem. Well, how did they figure out that there was a problem? How did they get access to know what Trump had and where he was storing it? Well, they had to get permission to go conduct an inventory so they could see where the gap was. And how do they do that? They have to have some sort of box opening. Pandora's box needs to be opened. And guess who did that? Guess who waived privilege that led to all of this spiral? Step one happened and then the domino effect started. Guess who did that? It's Joe Biden. Of course it is. He's the president. He's the person who makes these decisions. And so how did all of this unfold in reality? Well, let's take a look at the text of this document. And if you'll take a look, this was written back on May 10th. This came over from Just the News. And so we're going to pull this open and read through it in some detail. But before we dive in, I wanted to share where this came from. This came from a woman named Deborah, I believe is her name. And this is Donald Trump, who's actually sort of welcoming her or commending her on the anniversary of the ratification of the 19th Amendment in the White House Blue Room. And here she is. You're going to see Deborah's this woman back over here. Trump's there. There's Melania. They're saying, hey, nice job, Miss National Archives. I mean, gosh, you must have a lot of books to manage over there.
Deborah Steidel-Wall, Deputy Archivist of the United States. That sounds like a very big job. That's a lot of archives, isn't it?
A lot of archives.
How many buildings does that take up, right? Great job. I hear you do a great job. Thank you very much.
She didn't like that comment at all. At all. Which is why she's like, yeah, you want to indict him? Yeah, whatever records you need, I'm going to go get them for you. Oh, overdue library books? Criminal indictment forthcoming, I think. She didn't like that comment. You can see it right here. How many buildings are you representing? Look at her face right there. She closes her eyes there for that little pause. She's like, oh, God, this guy's talking to me. He hates women. And here we are. Yeah, she's very upset. So, okay. So now that woman sends a letter over to Donald Trump. And we just pulled that up. And so let's read that from the source, which is from John Solomon and his website over at justthenews.com. And so here's what he says, as you can see. It says, Just the News has obtained the full text of the letter that the National Archives sent to Trump requesting classified documents. And it came from the woman who Trump was just sort of congratulating. Nice job well done. May 10th. And this is going over to Evan Corcoran, who is Donald Trump's lawyer. It says, Dear Mr. Corcoran, and let me just back up on the date for a minute. Okay, this is in May right? We're now, so we went from May letters to to August raids, right? FBI raids. Pretty quickly. Not that long. It says, Dear Mr. Corcoran, I write in response to your letters of April 29th and May 1st, requesting that the National Archives further delay the disclosure to the FBI of the records that were the subject of our prior request in April. So National Archives sends a letter, presumably one of these April 29th or May 1st letters, and they say, listen, if you don't give us these records, we're going over to the FBI. Corcoran says, look, don't go to the FBI. Okay, we have authorization to do all of this. He's a former president or whatever they said. And they said, okay, we're responding to you. And we're specifically about your request to delay disclosure to the FBI. Deborah says, as you are no doubt aware, NARA had ongoing communications with the former president's representatives throughout 2021 about what appeared to be missing in the presidential records, which resulted in the transfer of 15 boxes to NARA in January 2022. Okay, again, like this is evidence that they are cooperating and communicating. We need the boxes back, boxes go back. In its initial review of the materials within those boxes, NARA identified items marked as classified national security information up to top secret and including sensitive compartmented information and special access program materials, right? That's the SCI language that you hear. That's all the top secret stuff that is ultra high security. NARA informed the Department of Justice about that discovery, which prompted the department to ask the president, the DOJ, to request that NARA provide the FBI with access to the boxes at issue so the FBI and others in the intelligence community could examine them. On April 11th, the White House counsel's office, affirming a request from the DOJ supported by an FBI letterhead memo, formally transmitted a request that NARA provided the FBI access to 15 boxes for its review within 7 days, with the possibility the FBI might request copies of specific documents. NARA says, Evan Corcoran, Trump lawyer, says, Evan, although the Presidential Records Act generally restricts access to presidential records in NARA's custody for several years after the conclusion of the president's tenure in office, the statute further says that subject to any rights, defenses, or privileges which the United States or its agency may invoke, such records shall be made available to an incumbent president if such records contain information that is needed to conduct the current business in the president's office that are not otherwise available. So they're making the point here that Biden needs those records. Trump, you've got those boxes. Biden's in charge. And if an incumbent president, if he needs those, then the law says that those records shall be made available to him. So presumably that means that Biden needs the records, right? So the basis of this is that if the records contain information that is needed for the conduct of current business of the incumbent president's office is not available, you got to give it to us. So Biden's sitting around saying, no idea what's going on there. Merrick Garland, who? Trump, who? No, right? He knows exactly what's going on. Because this is the pretext for getting all of this stuff. NARA is saying we need it because Biden needs it. Those conditions are satisfied here, is what they say. As the Department of Justice National Security Division explained to you on April 29th, this is your supervisor speaking language there, right? That's how you say, you're not getting this, dummy. You have to say, you type this to people in your emails. As I explained to you in my prior email, that means you're being condescending to them. So that's what she's doing. She says, as the Department of Justice National Security Division already explained to you in April, there are important national security interests in the FBI and others in the intelligence community getting access to these materials. FBI and others want these materials. Yeah, I don't doubt it. According to NARA, among the materials in the boxes are over 100 documents with classification markings comprising more than 700 pages. Some include the highest levels of classification, including the Special Access Program materials. Access to the materials is not only necessary for the purposes of our ongoing criminal investigation, but the executive branch must also conduct an assessment of the potential damage resulting from the apparent manner in which these materials were stored and transported and take any necessary remedial steps. Oh my goodness. So this is this is the librarian who is very angry. She sort of looked like a librarian, which is kind of what you want in the National Archives. And I happen to love librarians. So, okay, no offense to any librarians out there. Some of the best people, I sort of grew up in libraries. But it's a very, very, I guess it's less. Well, let's read what this says. So the librarian is sending this over to Donald Trump, and they say, look, not only are your library books overdue, but you might have damaged them. There might have been some potential damage from where you stored them. And when you're studying and reading late at night and you grab some Cheetos and you eat the Cheetos and you turn the page like, oh, darn it, Cheeto residue. So they're mad about potential damage. Now, accordingly, we are seeking immediate access to these materials so as to facilitate the necessary assessments that need to be conducted within the executive branch. We advised you in writing on April 12th that, quote, in light of the urgency of this request, we plan to provide access to the FBI next week. And we see a bunch of laws cited here. In response to a request from another representative of the former president, the White House counsel's office acquiesced in an extension of the production date to April 29th, and so advised NARA. In accord with that agreement, we had not yet provided the FBI with access to the records when we received your letter on April 29th, and we have continued to refrain from providing such access to date. So they're working with. I'm trying to sort of parse through this law. Yeah, the archivist may adjust any time period or deadline as appropriate. White House counsel office, so they're sort of quibbling over dates. So then she says, all right, listen. It has now been 4 weeks since we first informed you of our intent to provide the FBI access to the boxes so that it and others in the intelligence community can conduct their reviews. Notwithstanding the urgency conveyed by the DOJ and the reasonable extension afforded to Trump, your letter asks for additional time for you to review the materials in the boxes, quote, in order to ascertain whether any specific document is subject to privilege, which is his right, and then to consult with the former president so that he may personally make any decision to assert a claim based on constitutionally based privilege. So the librarian says, your April 29th letter further states that in the event that we do not afford you further time to review the records before NARA discloses them in response, we should consider your letter to, quote, be a protective assertion of executive privilege made by the former president. Saying, listen, I'm a lawyer for the former president, Trump. You want these boxes back. I think that these boxes are protected by privilege. You're demanding that they come back immediately. In fact, you're sort of threatening to bring the FBI to me. That's fine. So here's what I'm telling you if you're threatening me. I think that all of those documents are hereby privileged executively, and I'm going to be talking to my client, the former president, about these documents. And if you don't give us an extension of time, well, then that's your prerogative. But here's my position. They're all executively privileged. So I don't give a crap about your deadlines. And she responds and she says, well, I have consulted with my lawyers about this, the Assistant Attorney General for the Office of Legal Counsel, about this concept of executive privilege. Okay, because you wrote that in your letter. And I talked to him specifically about what I should do. And the counsel to the president has informed me, right? The counsel to the president, that is the President Biden, Joe Biden, said, in light of the particular circumstances presented here, President Biden defers to my determination, right? So the president's lawyer went and had a conversation with the president and said, hey, Joe, are you there? Joe, hey, I'm over here. And yeah, what? And he said, do you want me to prosecute Trump? And Biden, yes, he did. And so he says, okay, so you have to defer this to me. Give me the ability to make this decision. So this guy then, he does that. He says, President Biden defers to my determination, me, in consultation with the Attorney General for the Office of Legal Counsel about whether or not I should uphold the former president's purported protection of executive privilege, protective assertion of executive privilege. And so this gal says, accordingly, I have consulted with the AG for the Office of Legal Counsel to inform, quote, my determination as to whether to honor the former president's claim of privilege or instead to disclose the presidential records, notwithstanding the claim of privilege. And so she's going to do it. She's explaining that now. Here, I'm now telling you I have consulted and I am informing now of what my position is. So she tells us. Trump lawyer, Mr. Corcoran. She says, all right, Corcoran, Evan. The Assistant Attorney General, which is Biden's office, right? DOJ, yes, has advised me that there is no precedent for an assertion of executive privilege by a former president against an incumbent president to prevent the latter from obtaining the NARA presidential records belonging to the federal government, she says. Right. And that is a subject of debate, right? Whether that is true or not. We already talked about this at length with the Clinton sock drawer case. Clinton, and in that lawsuit, Judge Amy Berman out of the D.C. Circuit Court ruled against Judicial Watch and said Clinton's records were protected. The president gets to say what presidential records are, and you have to defer to him because he's the president. And if the NARA can say, no, Mr. President, I'm sorry, you're illegal. Who's really in charge? NARA or the president, right? It's obvious. You can read Amy Berman's opinion or listen to our show yesterday where we did most of that. Such records, she says, contain information that is needed for the current business of the incumbent's president office that is not otherwise available. So guess what happens now? Now, every single stinking document, right? My question would be as a defense lawyer, is every single one of those documents necessary for Joe Biden? And what is he doing with every single page in there? You walked out with 15 boxes, right? How many pages? Let's say, I don't know, several thousand pages in each box. So, I don't know, say 3,000. Let's say, would you fit 5-6 reams of paper in there? Okay, so 15 times 4,000, right? So let's say 100,000 pages of documents. Every single one of those pages, what was it needed for to conduct the current business of Biden's office? Why did the National Archives need every single one? Shouldn't they have to articulate every single page and paragraph to conduct business? So she says, all right, Evan, also to the contrary, Supreme Court decision strongly suggests that a former president can't even assert executive privilege against the very executive branch where it was invoked. She takes us through Nixon. She says the court rejected Nixon's argument that a statute requiring records from his term in office be maintained and says this would impermissibly interfere with it was screened by NARA's predecessor agency and said it's a very limited intrusion. This court specifically noted that an incumbent president should not be dependent on happenstance or the whim of a prior president when he seeks access to past records. And she's citing some actual excerpts from that law. So she says, listen, Evan, it's not necessary that I decide whether there might be any circumstances in which a former president could successfully assert a claim of executive privilege to prevent an executive agency from having access to the records. I don't have to say whether Trump could potentially win this argument. She says the question in this case is not even a close one. The executive branch here is seeking access to records belonging to and in the custody of the federal government itself. Not only to investigate whether the records were handled in an unlawful manner, but also, as the National Security Division explained, to conduct an assessment of the potential damage resulting from the apparent manner in which these materials were stored and transported and take any necessary remedial steps. Yes, the library books got, somebody put they didn't use a coaster. They used the library book and there's a ring around the cover of it. So they're upset about it. And so they say these reviews are going to be conducted by government personnel who are going to be sensitive to executive concerns. And so once we go and raid your home, we're going to take very good care with the documents we retrieve because, you can trust us. We're the FBI. We haven't been screwing you for the last 5 years and tried to derail your presidency multiple times. And she says, look, on the other side of this balance, there is no reason to believe that such reviews could adversely impact the ability of future presidents to obtain candid advice necessary to decision making. And one of the justifications for executive privilege in the first place, right, is so that you can talk candidly. Why do you have attorney-client privilege? So that people can't ask you what you talk to your lawyer about. It's protected for that reason. And it's very important so that you can be candid and have candor when you're talking about sensitive issues. So the librarian continues. She says, all right, Evan, because an assertion of executive privilege against the incumbent president under these circumstances would not be viable, she says, it follows that there is no basis for Trump to make a protective assertion of privilege, which the assistant attorney general tells me has never been made outside the context of a congressional demand from the executive branch. And now, even assuming for the sake of argument that former Trump may under some circumstances win this argument, there is no realistic basis that the request delay would result in a viable execution of that privilege. And so she's basically saying, even if you ask for this delay, you're going to lose the privilege argument anyways. And so you're only just delaying the inevitable. So the only end that would be served by upholding the assertion here would be to delay getting our library books back, and we need them. I have therefore decided not to honor the former president's protective claim of privilege. Deborah Nara, librarian, says return your books. For the same reasons, I have concluded that there is no reason to grant your request for a further delay before the FBI and others in the intelligence community begin their reviews. Accordingly, NARA will provide the FBI access to the records in question as requested by Trump beginning early Thursday in May. And please note, in accordance with the PRA, former president designated representatives can review the records. Please contact my lawyer, Gary, if you have any concerns about this. Sincerely, Deborah Steidelwall, acting archivist of the United States and America's librarian. And she wants those books back, and she wants them back right now. Now, Donald Trump responded to this on Twitter, on Truth, actually, which is where he is, of course, living now. And I am over at Robert Gouveia. He says in reaction to this, right, and before we get here, let's just recap what happened here. We know that NARA reached out to the White House to say, what about this executive privilege concept? What do you guys want to do about this? And Joe Biden and his lawyer said, well, nothing. We defer to you. The National Archive said, great. Therefore, we want to go see what you got. They did. They did an inventory. They were able to go and say, we found something missing. We don't like that you use these books for coasters, and we need them back. When they had a battle over this, okay, when they were fighting with Evan Corcoran about this, he says these are executively privileged. She says, no, they're not. She goes to the DOJ and she goes to the White House and she makes a decision and turns it over to the FBI. They don't battle this out in court at all. They turn it criminal, right? She could have said, well, okay, fine. You have an extension and we're going to file a second subpoena for those additional documents. We're going to file a lawsuit. We're going to duke this out in court until a judge orders you to give those documents over. But she didn't do that because why? She wanted to find something because that's how this all started. They needed a pretext. It's like, when police pull you over because your license plate light is out, do you think that they really care about your license plate? No. Everybody has headlights on the front of their cars. You can see people's license plate lights. Okay. So when your license plate light goes out, they're pulling you over. Oh, your license plate light's out. I wonder. Oh, did you have anything to drink tonight? Boom, you've got a DUI or your vehicle's being impounded because they smelt marijuana, burnt odor somewhere in the back of your car. Whatever. Same thing. It's pretextual. They need a basis to go and charge him criminally, and they have now done that. They've gone through NARA, and they got the subpoena, got a warrant. There was no urgency in the warrant, despite their best discussion on that. They raided his property, even though there was no particularity in the warrant. Overbroad, they seized passports, and now we're on step 8, where they're doing a discovery review. They're going to be using this, I'm sure, to launch off into new angles of investigation and to continue processing this forward. Then at some point, we'll get a grand jury and we'll see some type of criminal charge, maybe an obstruction charge, could be a records violation, presidential records or Espionage Act or something, or process crimes like they lied to FBI agents or to NARA or whatever. But whatever the decision is, they're going to make it become the end of the world, undoubtedly. Now, Trump responded to this on Truth Social, And Trump came out and he said the following. He said, the White House stated strongly that they were not involved. They did many times. Joe Biden came out and Karine Jean-Pierre said many times, Mar-a-Lago? No, I have no idea what you're talking about. No, Joe Biden's just biking all over the beach eating ice cream. That's what he does these days. Trump says they knew absolutely nothing about the political witch hunt going on with me, and that they didn't know anything at all about the break-in of Mar-a-Lago. This was strongly reiterated again and again. Wrong, he says, with an exclamation point. Remember, these are the people who spied on my campaign, true, denied it, true, and got caught, also true. Through the great reporting of John Solomon, fake Pulitzer Prize, ? He says. Documents reveal they knew everything and, in fact, led the charge. A political no from Donald Trump. Obviously. And this was always obvious. A lot of people would say, well, Rob, a lot of Twitter sophisticated intelligence, they were saying something like, Rob, the DOJ is not technically governed by Joe Biden, the president. And so Merrick Garland doesn't technically report to him and all this stuff. And you go, what? Have you seen the organizational chart of the U.S. government? I pulled it up here on the show. It's under the executive branch, which is the executive office of the presidency. So it's pretty clear how all of this works, but they're trying to pull a fast one over you. There's no conflict here because Joe Biden didn't know what his attorney general was doing. And so I'm saying to myself, wait a minute. Joe Biden didn't know that Merrick Garland was raiding the home of a former president. So that's insane. Like, that's worse than Joe Biden knowing, I think, because that just means Merrick Garland is sort of like this little dictator running around raiding homes. It's crazy. So obviously they knew about it, but they were hiding that for a long time. Now, here is a short snippet of John Solomon, the man himself, who actually broke this story. And he's talking about this with the representative named Jim Jordan on the program, sort of meandering about what this means.
We have new evidence. Just the News has obtained correspondence between various parties during the lead up to the raid showing that the Biden White House, that's right, Joe Biden's White House, the one that said they had nothing to do with this, they were deeply involved in the early instigation of the criminal probe against President Trump, including clearing the way for the President Trump's claim of executive privilege to be eviscerated, basically getting rid of his executive privilege before he could contest it. That occurred just before a grand jury started delivering subpoenas looking for the records. So for the first time,
So they're clearing the field, right? They're just setting it up. They've got all of the pins set up, and you just you hit it, knock them all down. Now, when we fast forward through this a little bit, we see that they actually get...
Go ahead and do it if you want. And that allowed a grand jury to drop a subpoena in the President Trump's team not to be able to contest the subpoena using executive privilege. We have that letter. We showed a little bit on screen here. Your thoughts of the Biden White House being in the middle of this right from the start?
Well, I guess it doesn't surprise me at all. I mean, remember, we had heard it been reported that the Attorney General had deliberated for weeks. So during that time, if he's deliberating on what to do and whether they're actually going to, have the raid on President Trump's home, it seemed likely to me that he'd talk with the White House. Because remember, this is the same Justice Department and same White House who coordinated with the school board, National School Boards Association, before they, in fact, initiated the letter as the pretext for the Biden administration taking the action against moms and dads that they took last fall. And as far as we know, and basically according to what whistleblowers have told us on that issue, they continue to do. So it shouldn't surprise us that the Biden White House was in on this from the get-go, because that's what I always suspected was the case anyway.
Yeah, obviously they were involved. They were always involved. The whole thing was a political hit job. They're just ratcheting it up one after another. And so Joe Biden obviously knew that this was all happening. The White House feigning ignorance of the whole thing is laughable at best. We also have new updates from Donald Trump. Here we've got several updates. We're going to hit two different dockets here today. The Donald Trump warrant judge rejects the FBI sealing of the warrant's affidavit. Let me say that again because I said that wrong. The Trump warrant judge rejects the DOJ's attempt to seal the FBI affidavit, ordering redactions due shortly. We're going to go through the order that came out on August 22nd. We're also going to take a look at the Gang of Eight. You know these people, Intelligence Committee, so-called Congresspeople, who serve on all of the subcommittees, and they're supposed to guide America through trying times. They want access to the affidavit. And then we'll take a look at both dockets, the search warrant docket and Trump suing the government to appoint a special master. But before we jump into anything, we want to start here. This is Judge Reinhart's orders on the motion to unseal. And this is the battle, the culmination of the battle that has been taking place for some time here. Remember, Merrick Garland came out and he said that they were going to unseal portions of the search warrant. It was really only the cover sheet and the inventory list. Trump came out and said, release everything. And then the DOJ returned and they said, actually, we don't want to unseal the affidavit because of a couple things. One, it's going to be problematic for our investigation. Other presidents that we're incriminating, might know what we're doing. And they didn't want people to get more details about who was leaking to the DOJ and who was involved. And so they responded and they filed a motion opposing the unsealing. And last week we had oral arguments with Judicial Watch and a bunch of other media companies, ABC, New York Times, Washington Post. They were all skidding in there to try to get the court to unseal these records. And the judge came out with a very interesting ruling. He said, well, he sort of hemmed and hawed. He kind of kicked the can down the road and didn't give us many answers. But today, or yesterday, at the close of the day, he did. He said on August 22nd in a 13-page order, here's what I'm actually ruling, right? And we cut this last time. We said, I don't know if he's going to unseal this whole thing or not, because he said at present was the language he used. He says, at present, I'm not convinced either way. The government hasn't met their burden, but they haven't not met their burden. And so some people were saying, oh, he's going to release it. And I said, hold on a minute. He's saying at present, and it was kind of a weak kick the can down the road argument. Yesterday on August 22nd, he did come out and clarify all of this for us. So here are his orders now on this. He says, all right, on August 8th, the government raided Trump's home. Presidents are a private club that is also a part-time resident of Donald Trump. He said a lot of people were crashing in here to go and unseal this affidavit so that they could see it. Specifically, Judicial Watch came in hot, Albany Times, New York Times, NBC, Cable News Network, CNN. We've got WAPO, EW Scripps, Miami Herald, Time, Dow Jones, everybody. They all asked for the unsealing of the affidavit. But they write, the judge says, the government opposes the request to unseal. Okay, so media wants it open. Government wants it closed. This order is memorializing and supplementing my rulings from the bench hearing that took place back on August 18th, because it was kind of a mess. We didn't know what was going on. He says, the judge, neither former President Trump nor anyone else purporting to be the owner of the premises of Mar-a-Lago has filed a pleading taking a position in any of this stuff. Trump lawyers haven't taken a side. Nobody who is a part of Mar-a-Lago has filed anything. So the judge says, let's just get that out of the way and clear this up. Judge Reinhart writes, on August 5th, 2022, the court issued a search warrant for the premises after finding probable cause that evidence of multiple federal crimes would be found at the premises. This judge signed off on that warrant. An FBI special agent's sworn affidavit provided the facts to support the probable cause finding, right? That's the written document. The government submitted 1, a criminal cover sheet, 2, an application for a warrant, 3, an affidavit, 4, the proposed warrant, and then 5, a motion to seal along with an order to seal, all as part of this warrant package. Now, the government asserted there was a good cause for sealing the entire warrant package. They said public disclosure might lead to the investigation being compromised or evidence being destroyed. And that's all pretty usual. The motion to seal the entire warrant package was granted, and after the search on August 8th, the government filed an inventory of the seized items as required by code. Go raid the property, let us know what you find, make sure you file the inventory so that if there's any objections or issues with what you stole or took, then we can contest that, okay? They did it. Beginning on August 10th, interveners, so those are all the media companies, filed motions and they wanted to unseal the entire package. On August 11th, the government moved to unseal the warrant and a copy of the inventory that had been redacted only to remove the names of the FBI agents. Court granted the motion to unseal, and they are now publicly available. And so they say those motions are moot. We don't have to argue about those. Okay, we got the cover sheet. So the judge is dividing the warrant package up by numbers. Okay, 1 was the cover sheet, 2 was this, and 3 was, okay, 1 and 2, done. Don't need to argue about those. But what about the rest of the package? It says on August 12th, 2022, the government filed under seal redacted copies of several other documents from the warrant package. And we haven't seen these because they're all under seal. The criminal cover sheet, the warrant by telephone, and other documents. They were also redacted to conceal the identities of the U.S. prosecutors, the U.S. attorneys, as well as the FBI special agents. And the government does not oppose unsealing those. Interveners do not object to the limited redaction. So they said, okay, look, we'll unseal some of those, but we also want their redactions of their names. Are you cool with that? No problem. Yes, sounds good. Judge says, I find that the redactions are appropriate. Yeah, I protect the identity and the personal safety of both the prosecutor and the investigator. So we'll do that. And so we're granting those motions as well. Okay, so some new motions will be unredacted or unsealed. So the judge is clearing out the rest of the warrant package, right? So basically we need to see the affidavit. It's all that's left. It says, okay, all that remains then is to decide whether the affidavit should be unsealed in whole or in part. And we didn't have a lot of debate over this or a lot of answers about this during the last proceeding. It says, with one notable exception that is not dispositive, which is dispositive meaning it doesn't decide the entirety of the issue, the parties agree about the legal principles that apply. As discussed below, the parties disagree about whether there's a First Amendment right to public access of these documents. They disagree only about how I should apply those principles to the facts here. So they both say, okay, it's First Amendment, and we just don't know how it should be applied here. The government concedes that it bears the burden of justifying why the affidavit should remain sealed. We have a presumption of public access, that we have a right to see this stuff. So why are they wanting it sealed? They've got to make the justification. So the judge laid all that out as foundation and then gets into the meat and potatoes. He says, look, we've got some pretty applicable legal principles here in America. And he says it is a foundational principle of American law that judicial proceedings should be open to the public. Now, I could rant and rave about this point till the end of the earth. You know, every federal court proceeding is largely closed, but they start their sentences like this. Like you can't call in or they don't video broadcast anything. And including in this proceeding, this judge didn't allow you to call in for this last hearing. So he says, okay, it's a foundational principle that judicial proceedings should be open to the public, as he has one of the most closed courtrooms in America. All right. An individual's right to access judicial records may arise from the common law, the First Amendment, or both. And he gives us some case law. He says, where a sufficient reason exists, a court filing can be sealed from the public view, but you got to have a good reason for it. And he gives us some case law, this case out of the 11th Circuit, 2007. They talk about how you decide whether there is good cause. What are the elements, the indicia that the government can proffer to justify sealing documents? Well, here's a couple of them. Courts can consider, among other factors, the following: whether access would impair court functions, right? So put a 1 there. Or harm privacy interests. That's another factor, number 2. Likelihood of injury, if it's made public. That's the 3rd variable. The reliability of the information, number 4. Opportunity to respond, 5. Information about public concerns, 6. And whether there's the availability of a less onerous alternative, number 7, right? And so you've got, 7 different balancing factors. That's a lot of them. You got to weigh all of these out and say, well, does Trump have legitimate privacy interest in some of this stuff getting out? Well, yeah, he does, of course. But does the government have privacy interest in their investigations? Yeah, I guess they do. So we got to balance them out. And the judge is going to do that for us right now. He says, look, they also consider whether records are sought for such illegitimate purposes like promoting public scandal or unfair commercial advantage, or whether they're going to promote public understanding of historically significant events and all sorts of other stuff. Very important that we get access. But the judge says, Despite the First Amendment right of access, a document can be sealed if there is a compelling government interest and denial is narrowly tailored to serve that interest. You got to match them up together. Why do you want this thing sealed? And can we do that in a way that is extremely narrowly tailored so that we don't have an overbroad prohibition that harms other legitimate public interests? Says the 11th Circuit, which they're in, has not resolved whether the First Amendment right of access applies to pre-indictment search warrant materials. So it hasn't been litigated yet in this court, which is kind of amazing, isn't it? I mean, we've been around for a while. It's kind of interesting to think about this, like new issues come up that have not been litigated. This is one of them. The government argues, quote, the better view is that no First Amendment right to access pre-indictment materials exists because there is no tradition of public access to ex parte warrant proceedings, meaning that if the prosecution just goes and gets a warrant outside of the sort of scope of the defense, they don't get to see it because the defense doesn't even get to see it. Why would the public? Nevertheless, the government says that I need not resolve this question because even under the First Amendment test, a compelling reason exists for continued sealing. The judge says, I do not need to resolve whether the First Amendment right of access applies here. Not even going to consider it. He says, as a practical matter, the analysis under the common law and the First Amendment are basically the same. He says, one, we look at the party, whether they're sealing it and whether they have a sufficiently important interest in secrecy that outweighs the public. So more interest in secrecy here than public knowledge or vice versa. And two, whether there is a less onerous or said differently, a more narrowly tailored alternative to sealing. Like, do we have to seal it? Can we just redact it? Here, the judge says, as I found and I discussed below, both tests lead to the same conclusion. And so we'll fly through the discussion, but it says, look, we got to balance the parties' interests here. The government argues that unsealing the affidavit would jeopardize the integrity of its investigation. The government says, as the court is aware from its review of the affidavit, it contains, among other critically important and detailed investigative facts, highly sensitive information about witnesses, including witnesses interviewed by the government and specific techniques. All of that needs to be kept under seal to protect the integrity and the secrecy of our investigation. But the judge says, in the context of an ongoing criminal investigation, the legitimate government concerns that they have, they include the following: witnesses and their cooperation, law enforcement's ability to use certain investigative techniques, obstruction issues, and whether charges are brought at all, and reputational damage. Okay, so these are all the things that they can consider. And the judge says, as the government themselves aptly noted at the hearing that we already talked about, these concerns are not hypothetical in this case. One of the statutes for which I found probable cause was 18 U.S. Code 1519, which prohibits obstructing an investigation. Oh, you see that there. Judge took a look at this and he said, obstructing an investigation seems like it might fit. Also, as some of the media interveners have reported, there have been increased threats against the FBI. And he cites a bunch of articles from that. Cincinnati man in Ohio and so on. A lot of articles. After the public release of an unredacted copy of the inventory, FBI agents were harassed. And he cites a Business Insider article. Given the public notoriety and controversy about this search, it is likely that even witnesses who are not expressly named in the affidavit would be broadly identified over social media and could be harassed and intimidated. And he says, all right, look, balancing all of these interests together, balancing the government's asserted compelling need for sealing against the public's interest in disclosure, I give great weight to the following factors. 1, there is significant likelihood that unsealing the affidavit would harm legitimate privacy interests by directly disclosing the identity of the affiant, which is the FBI agent, as well as providing evidence that could be used to identify witnesses. As discussed above, these disclosures could impede investigations, and he says this factor weighs in favor of sealing. Okay, he's going to go through all of them and just put one on each side. The affidavit discloses the sources and the methods used. I agree with the government that it does contain critically important information. This factor weighs in favor of sealing. The affidavit discusses physical aspects of the premises, which is the location protected by the Secret Service. Disclosure of those details could affect the Secret Service's ability to carry out their protective function. And so that factor weighs in favor of sealing. And as the government concedes, this warrant involves matters of significant public concern. And so certainly unsealing the affidavit would promote the public understanding of historically significant events. And this factor favors in favor of disclosure. So balancing them all out. So far, if you're keeping count at home, it looks like it's 3 for sealing and 1 for disclosure. So it's not looking too good here. Now, the media and the interveners, they're emphasizing the court is required to consider if the press has already been permitted substantial access to the contents of the records, right? And the DOJ has been leaking like a sieve. They've been leaking out, nuclear codes. And today was a new one, 300 documents. And so they go from letting you fill in the gaps with your imagination to then filling it in with nuclear codes to then going from a nuclear code threat to a volume type of a threat. It's the 300 overdue library books. But if they're leaking all of this out to everybody, if they're telling us that this was a letter about Kim Jong-il or this was a letter from Barack Obama or whatever, well, the media already knows what's in the records. And so sealing the records just to keep them sealed when we already know what's in them, it's like, hello, you're not bluffing. We can see your cards, dummies. Just show them already. We can already see them. The government acknowledged that the unsealed warrant and inventory already disclosed the potential criminal statutes at issue here. And we've got that. One intervener argues that there is no privacy interest because Trump and his counsel have spoken repeatedly about the government's search and publicly disclosed information about the subject of the search. Another intervener is saying all of this is already public. A third says the investigation has been made public by the target of the warrant himself. Everybody is demanding openness. Members of Congress have demanded the Justice Department provide an explanation. In short, with so much publicity surrounding this, the court should be skeptical about the government claims that this is going to invade privacy. So the judge is going through all of the interveners and just sort of cataloging their objections to continuing to keep it sealed. So the judge says, look, no one disputes that there is a lot of public discourse about this warrant, okay? I signed it. Says, nevertheless, much of the information being discussed is based on anonymous sources, speculation, or hearsay. The government has not confirmed its accuracy. No, they just leak it to the New York Times. In any event, these arguments ignore the contents of the affidavit identify not just the facts known to the government, but the sources and methods used to gather those facts, like what witnesses were involved and what type of investigative techniques they used. That information is not known to the public, and for the reasons discussed above, the government has a compelling reason not to publicize that information at this time. Judge writes, I do not give much weight to the remaining factors relevant to whether the common law right of access requires the unsealing. Allowing access to the unredacted affidavit would not impair court functions. Doesn't impact us. Having carefully reviewed the affidavit before signing the warrant, I was and am satisfied that the facts sworn by the affiant are reliable. Saying, I think that FBI agent, he's pretty on the money. So releasing the affidavit to the public would not cause false information to be disseminated. So that sort of goes in favor of unsealing it. He also says there is no indication here that the media seek these records for any illegitimate purpose. They all want it for good reason. So the judge says, gosh, he's stroking his chin. He says, after weighing all the relevant factors, I find that the government has met its burden of showing good cause / a compelling interest that overrides any public interest in unsealing the full contents of the affidavit. So the judge ruling that the full thing is not going to be unsealed. Government has met its burden, but says, I still have one more thing to consider. Remember in there about that less onerous alternative? Is there any more narrowly tailored opportunity here? The government argues that redacting the affidavit and unsealing it in part is not a viable option because the necessary redactions would be so extensive as to make the whole thing meaningless. It would just be a big blanked out document. Judge says, but I cannot say at this point that partial redactions will actually do that, he says. I may ultimately reach that conclusion after hearing further from the government, but I can't say at this point, okay, this is hedging words, just like he said last time, at present. I cannot say at this point that partial redactions will be so extensive that they will result in a meaningless disclosure, but maybe. And this is honestly what he did last time. He sort of said, I can't imagine me sealing the entire affidavit. And then he came out today and he said, I am basically sealing the entire affidavit unless you can show me redactions, and I am open to having redactions, submitting some of them, but not all of them, right? So he's still kind of not real sure. He says the government argues that even requiring it to redact portions of the affidavit that could not reveal agent identities or sources or methods imposes an undue burden on its resources and sets a precedent that could be disruptive and burdensome in future cases, I guess future presidential raids. It says, this is the judge, I do not need to reach the question of whether in some cases these concerns could justify denying public access. They very well might, particularly given the intense public and historical interest in an unprecedented search. You see that? Of a former president's residence. The judge himself says, yeah, unprecedented search. The government has not yet shown that these administrative concerns are sufficient to justify sealing. So he's coming at it from both angles. The government, he writes up here, has met its burden that the entire affidavit will not be unsealed. But then he says down here, also not enough to justify total sealing. So he says, finally, I therefore reject the government's argument that the present record justifies keeping the entire affidavit under seal. In its response, the government asked that I give it an opportunity to propose those redactions if I decline to seal the entire affidavit. I granted that request, and I gave the government a deadline on noon this Thursday, August 25th, which of course we will be covering. Make sure you're subscribed so that you don't miss it. Accordingly, it is hereby ordered that by that deadline, the government shall file under seal a submission addressing possible redactions and providing any additional evidence or legal argument that the government believes relevant to the pending motions to unseal. Done and ordered in chambers, August 22nd, signed by Bruce Reinhart, United States Magistrate Judge. So, a big motion with a lot of meat there. The judge calling this unprecedented, saying that this has never happened before, raiding and searching a former president's residence, but still not too sure about redactions and whether or not we're going to see full redactions or not. Now, the Gang of Eight, a bunch of Republicans who are on these so-called intelligence committees in our United States Congress, they want access to the Mar-a-Lago documents. And you can see these two yahoos here, Mitch McConnell and Chuck Schumer. They want to see it. They sent a request over calling it the latest sign Congress is trying to get some insight into what is going on here. A group of congressional leaders charged with reviewing the most sensitive information has asked the Biden administration for access to the documents that were seized. Two people with direct knowledge of the request told Politico. And I think that probably comes from the Gang of Eight, right? Knowledge of the request comes from them. The inquiry from the so-called Gang of Eight comes as lawmakers from both sides want to know about the unprecedented investigation into the former president. Similar requests coming from other people: Mark Warner, VA, Virginia, Vice Chair Marco Rubio, Florida. They're asking for the affidavit. It includes, let's see who's on this list: Chuck Schumer, Mitch McConnell, Nancy Pelosi, and House Minority Leader Kevin McCarthy all want access to the affidavit. We'll see if the Biden administration gives it to them. But those are the docket updates in both Trump and the Trump versus United States docket. Looks like this. Not a lot of activity here today. He filed a lawsuit, sort of a demand for the appointment of a special master. And we saw a little bit of activity here today. The judge is saying you have to refile your notices or motions to appear pro hoc vice to some of Trump's lawyers. So sort of a refiling is needed. We have on August 23rd, the judge is also asking Trump's lawyers to determine or to file a supplemental motion about why they think this court can grant them a remedy. See this here? They say, Trump, you and your team, you have to tell us what your asserted basis is for this court's jurisdiction, whether it's legal, equitable, anomalous, or both, whether you're bringing this as a legal cause of action or an equitable cause of action. They are different. The framework applicable to exercise our jurisdiction, and the relief that you want, including an injunctive relief pending resolution of the motion, right? So sort of what specific order do you want? The judge is saying we need more details, and then I want to know about service, and that's it, right? So not a huge update there on the Trump docket there, but that is the major update. Trump judge rejecting the sealing of the entire affidavit, but very likely going to be considering some pretty hefty redactions. We'll have to wait on Thursday to see what those look like, and we'll of course be covering that. I hope you do join us by subscribing and liking this video so that, the algorithm knows that we're here. Let them know that we're here. And we've got one more segment to get to on the program today. Steve Bannon is warning Merrick Garland. He's saying, hey, you're not going to be in charge forever, my friend. And when the Republicans take back over, it might be time to put you in prison. Steve Bannon, of course, has just been convicted of 2 counts, 1 contempt of Congress for not showing up to the fake January 6th Select Committee garbage hearing, and 2 for not bringing documents when he was supposed to go. And we're going to go through a motion that his team has filed in response to those convictions. And it is a doozy. It's a long one, and it's got a mouthful right there. You can see it. Defendants reply to the government's response about a supplemental brief concerning a motion to exclude, about a motion to quash, about subpoenas. So we'll go through that and see if there's any sort of opportunities there for Bannon to reverse his convictions. But first, we had this clip that came out from Steve, and he's on War Room here, and he's telling us that, Republicans are going to be winning at some point, and the balance of power shift may not work out so well for the Democrats. And we're going to take a look at a poll that shows Donald Trump might be doing pretty well. Let's see.
The FBI is a Gestapo. The Just Part, Merrick Garland, you're going to go to prison, brother. We're going to be so relentless when we take power this year on your impeachment. But then after your impeachment to file criminal charges against you, you people are pure and entire scum. Okay? You have weaponized this from the beginning. You're trying to criminalize against Trump. The only way you can stop MAGA and stop the ascendant movement of MAGA is quite simply, you're going to try to use law for it. Well, it's not going to work. We're not going to tolerate it. Okay? That's it. We're going to massively win at the polls. Then we're going to impeach you guys. Then we're going to put you in prison.
Now, he's talking about some polls. And, Merrick Garland, you might have to have some real concern about that. I mean, if they're going to be indicting former President Trump and taking, sort of implying he should go to prison, Steve Bannon implying he should go to prison, if the balance of power changes, you'd expect sort of the same tit for tat, wouldn't you? Well, if that does happen, we're going to be playing the field and seeing how the candidates are measuring up against one another. But as you can see here, there was a new poll that came out from YouGov America, and they told us this. On this program, we've been speculating that what happens if Liz Cheney runs? She might actually peel off some Republicans from Donald Trump, right? She could primary him, have standing to file lawsuits against him, do a whole bunch of things as an annoyance, nipping at Trump's heels if she does actually run. But maybe that's not the reality. Maybe she doesn't siphon anybody off from Trump. She siphons people off from Biden. Here's this poll. YouGov America says, if Liz Cheney were to run as an independent in 2024, she would take more support from Joe Biden than from Trump. 2024 in a 3-way matchup, Biden 32%, Cheney 11%, and Trump 40%. The victor and America's president. If Liz Cheney were to run, you can see the breakdown. This is what it looks like in the polls. You can see Joe Biden or Trump. Looks like Joe Biden wins that one. But if Cheney runs, she actually pulls people away from Joe, and Trump squeezes out a victory. Now, there's a lot of additional polls there. Gets very interesting if you throw Ron DeSantis into that mix and how the split continues to unfold. But we are going to take a look now at Bannon's motion, because he, of course, was convicted, and now he's fighting to reverse those convictions. And we have this interesting motion that was filed on August 19th. It is 8 pages long, filed out of the D.C. Circuit Court, which is where Steve Bannon was convicted. And it's the United States of America versus Steve Bannon. And look at the whopper title of this motion. I mean, my goodness, it makes your head hurt. Let's see if we can parse together what's going on. Remember that the court, let's start at the end, granted the motion to quash Steve Bannon's subpoenas. He asked the court to haul in Liz Cheney and Benny Thompson and Jamie Raskin so that they could be cross-examined and he could confront his accusers. But the judge said, no, that subpoena is quashed. I'm granting that. They're not ordered to be here. They don't have to testify. So what Steve Bannon's lawyers did is they said, well, Judge, we think that you should exclude any congressional evidence and dismiss the indictment because we didn't get to present a case. I mean, how can we have a fair trial if we're not even allowed to call witnesses or present evidence? Kind of hard. But that's exactly what happened. And so they said, all right, we need a motion to dismiss the indictment. But then the judge said, all right, well, you better brief these issues because these are complicated issues. So can you go brief these things? And so they wrote, all right, fine. So they filed a supplemental brief supporting their original request. The government responded to that supplemental brief. So Bannon's lawyers came out and said, hey, you must dismiss it. The lawyer said, don't dismiss it. The judge said, can you supplement this? They said, happy to. Then the government responded to the supplement, and now they're replying to the response of the supplement. Woo! My goodness. All of that is from one sentence. Okay? That's what's happening here. That's the procedural posture. Good Lord, lawyers, right? Bunch of weirdos. It says on August 5th, defendant Steve Bannon, through under counsel, find the supplemental brief, and now all of what I just explained, they're explaining. The prosecution argues in its page 2 of its response that the court should not engage in any balancing of Bannon's constitutional rights against the privilege of the subpoena recipients. And so again, balancing factors here. Bannon says, how can I have a fair trial if I can't even call my witnesses or present evidence? And they're saying, yeah, but these are Congresspeople. They have a right to be, privileged against these types of subpoenas. And so Bannon is saying the following. He says, this argument was not raised in the prosecutor's response, and it's also undercut by the authority from the circuit court. And contrary to the government's assertions that we talked about here in oral arguments, there is no requirement to show government misconduct in denials in order for relief to be granted. So they continue. Bannon's defense says, look, in typical fashion, the prosecutors here, they cite cases that support its position, but they omit the fundamental details. They cite this case from a 2014 DC case, United States versus Verarusio, and they argue about the speech and debate clause in that. But here, the prosecution neglects to tell the court that in that case, Verarusio, the defendant waived the entire balancing argument by failing to raise it. So they're trying to distinguish this, and they're neglecting to tell you about a key variable that differentiates that case from the Bannon case. They say to the extent that the defendant made a secondary argument in that case, it's different here. That is not so in the instant case, saying the government prosecutors are also relying on a 1995 case called U.S. versus Dean. But here, the prosecution again failed to advise this court, being dishonest to you, Judge, that Dean waived a primary argument he made in trying to show the materiality of the quashed testimony. There was no proper legislative purpose, so the court could not even address it on the merits. So they're trying to show you a case, Judge, that says, look, this is how this court did it. But in that case, it's totally different than this one. In that case, Dean claimed that if the subpoena had not been quashed, the testimony he sought would have proven that the substance of his perjurious statement was actually true. Here, they're saying the cases are in opposite. At pages 5 to 13, prosecution argues that Bannon has not identified any information denied to him, and that is untrue. They say Bannon relies on previous written and oral submissions to demonstrate the material prejudice that he suffered by not having those subpoenas granted. If Bannon can't call witnesses, it's clear he was prejudiced. And that's been brought up in this trial multiple times. I mean, in written and oral arguments. So yeah, I don't know why the prosecutors would assert that. He's demonstrated favorable and material nature of the testimony time and again. Bannon addresses one prime example of this testimony. He says that as the court is aware, the one defense that the court allowed Bannon to use was a mistake of fact defense. Bannon made clear that this was part of a larger function and part of a larger exchange. And so they're going through the government's motion sort of bit by bit. They say Bannon refers in some detail to letters between his lawyer and Benny Thompson about the flexibility of the dates, which was another point of contention. Remember when Bannon was and his lawyers were responding to the letters from the J6 committee, they respond after the deadline came and went. Bannon, was supposed to show up on, I think, October 8th. He didn't. They said, okay, now you're in violation of the law. No, that's not true at all. They said, if you would like to show up at a later date, we'd be happy to do that. And that sort of implies that by not showing up on that particular day, that there wasn't actually a violation of the law. So they're fighting over these dates, especially the flexibility of the dates, saying that Bannon thought he was in compliance, didn't refer to a default when he sent a letter back. When Benny sent a letter back over to Thompson, he didn't say, you're now a criminal, right? He said, well, we'll just show up when you can and we'll talk to you. So the prosecution is making all of these arguments. They're grouping all of these things into one big bucket. But it says, based on the foregoing and all of the following, we do think that the case against him should be, here it is, dismissed based on a violation of his fundamental constitutional rights. They say that you denied his ability to call witnesses, you granted the congressional motion to quash, and therefore we were denied our due process under the law. Signed off by the two attorneys we know, Evan Corcoran and David Schoen. Schoen, I think, is how, good logic, Joe Neerman corrected me. But they signed off on that. And of course, we are still going to have to wait for a ruling from the Bannon judge. And when that comes down, we'll see what that says. And of course, report that here. And so I do hope you are subscribed to this channel so that you can follow along. Steve Bannon is making stern warnings to Merrick Garland, and we'll see what the judge rules. But that, my friends, is it for the segments and the show. And now it is time to hear from you and to see what you have to say about all of this. And we got Paul Minot at the start of the program, but one more shout out to Paul Minot and to Lucinda Turner, artist from British Columbia. Paul said, in honor of British Columbia, I think BC artist Lucinda Turner, her family took me in and changed my life. A fighter for justice and one of the best friends I ever had. She never gave up. I love you. Wait for me at the gate, which is just a beautiful statement. And so much love to Paul. Much love to Lucinda and her family. Shout outs to General Kale, who says vegan cats, trans kids, and the FBI all have one thing in common. We know who's actually making the decisions. Okay. Who is it? Who's making the decision for the vegan cats? I don't know. I don't think vegan cats is not a healthy thing. Cats are supposed to have meat in their diet. I watched that in a documentary. Thank you, General Kale. We've got Rod7355. He says, hey, Robert, great work. What they, DS, are doing to President Trump is trying to make him damage goods. But while in the process, they are destroying themselves. I think that's true. I think they're setting really bad precedent. And it's going to come back to bite them in the derriere, in the butts at some point in the future. And it may be sooner than they think, right? If the Republicans change, if the Senate and the Senate may not flip, but if the House flips, then you've got sort of an ineffective lame duck presidency for Biden. And then if the balance of power flips in 2024, Republicans take over. Maybe they're investigating. If Donald Trump runs the DOJ, you think he's going to be happy about any of this? I don't. Shout out to Jeff Pearson. He says, Fox reported my buddy Brian Outen is part of the team reviewing documents captured during the raid. Allegedly docs about Outen. Yeah, and so that's part of the Crossfire Hurricane team, right? Wasn't he somebody who was also part of the investigation originally into Trump? And he's part of this new investigation? There's articles about that. I think I put that in my mind map, although I don't know that we've actually talked about that one. Thank you, Jeff. Yeah, wild. Patrick says they need documents so that they can shred them to cover up their crimes. Probably true. Bear Ashby says Biden knew that's why he's staying on vacation. Yeah, so he timed it. Just don't do it when I'm here. Just make sure I'm not here when you do it. Good to see you, Bear. John Get Trust became a member. Shout out to John Get Trust. And that's awesome. We have our morning walk and talks that we've been doing for a while now. Very, very consistent. And so been a lot of fun. I get into the comments and get to hear from you sort of on the daily headlines. And so members get that. And John is going to get that. Mark Pate says, good, dissect it. It was very enjoyable. Well, thank you, Mark. I'm glad that you got to join us, and I appreciate the support with the super chat. SR Dempsey says, thank you for your detailed info and sense of humor. Well, thank you, SR. I'm glad you find it humorous. I know I do, but sometimes who knows if you do. Probably some of you don't. Maybe most of you don't. I don't know. But somebody likes it. Thank you, SR. I'm glad that you're here. Appreciate it. Daryl Courier says, swear jar donation. Don't you hate that, Daryl? Thank you, Daryl. Appreciate it. Sharon Hatt became a member. Welcome, Sharon. Glad that you're here joining us. Morning Walk and Talk will be hot and fresh for you tomorrow. Just Cause says, hey, Rob, let's take a second and speak about what is acceptable for chat. Obviously, no hate speech. Please specify about profanity or attacks against you. Appreciate it. Much love, the mod team. Wow, that's a good question. So, Vianticus sent me a Twitter about this also the other day, a tweet on this. And, I don't really know what to do about this issue, if I can be honest with you. I mean, I'm not, I'm a criminal defense attorney, so I kind of don't really like a lot of rules. And, when you have a bunch of rules in place, then I don't want people fighting and quibbling over the rules, but I certainly, don't want the mods to, to get mad or upset or to have a difficult time. And we want, when I started the program, the general rule was dinner table manners. I kind of thought that was sort of like a good standard. It's like dinner table manners, like, no profanity. You try to be polite. You try to let other people speak. You don't hog the conversation. You don't, commandeer it. You're generally respectable to the host. It's kind of nice. It's kind of nice manners. But certainly you get into heated debates and stuff, and you can, challenge everybody and, say, I think your ideas are stupid, host, and, this meal was okay. It was all right. Thank you for having me over, but, not the. But as I said, every now and then you have, little Sally who says, Uncle Tom, or something happened there. Or, what the Uncle Joe Biden shows up to your dinner table and all the kids flee out of the room, Oh, great. Uncle Joe's here for dinner. I'll eat at the kids' table tonight. Jeez Louise, what room is that in? Or somebody throws a plate of broccoli at the wall. So, it's hard for me to come up with cut and dry rules. I don't know what other chats do, or if there are other rules, or if there's other, generally though, right? I think that profanity is just not necessary. It doesn't add a whole lot to the conversation. I also sometimes, would like to be able to pull up the chat. And if there's a bunch of profanity in there, then it's a problem. Lean says, get to the point. I don't really have a whole lot of a point. Yeah. Somebody says Rob's a turd. Okay. That's fine. I don't care. Whatever. But I think that generally, sort of a lot of the profanity is just not really necessary generally. But, I don't like, I'm not going to, I don't have to kill myself over that rule. If everybody wants to come in chats and just drop F-bombs all day and like, that's the point of the chat. No, I don't know. Yeah. V says the problem is there's no right answer. Yeah, there really isn't a good answer. So, I mean, if you, if I have to just make a decision on it, I guess, I'm more inclined to have less rules if I have to be honest about it. But, I personally don't care about personal attacks on me. Again, as long as they're sort of like the theory is you want a productive, fun chat, right? You don't want a bunch of disorder, let's say deviating conversations in the chat. I don't know. It's very complicated. All I know is I love the chat and I love all of you. And I just want friendly, peaceful conversations where we all just get along, man. Can't we all just get along? Like at a nice dinner table. So I don't think that gave any real clarity, but Just Cause. Profanity or attacks against you. So look, honestly, I think if they're like sort of productive, or if they're contributing, right? If somebody's just spamming, Rob's a turd over and over and over again, like that's not really productive. But if somebody wants to, contribute to the conversation and say these ideas are bad, like that's what we want. We just don't want a bunch of distractions in the chat, because I think that takes away from the people who want to talk. Right? Isn't that sort of what the chat is for? I don't know. I'll have to think about it. Or maybe I'll do? Maybe I'll reach out to Viva and to some of the professionals. That's what I need to do. I got to talk to the professionals about this, right? I don't know what the hell I'm doing. So I got to talk to them about it. Thank you, Just Cause. I will do that. I'll take you up on that. Yeah, don't break the law. Don't spam. Kill bots, says Dan. That's a pretty good rule. Yeah. Rob can obviously handle. He's got thinnest. Yeah, the attacks, the personal attacks don't bother me at all. At all. They're actually kind of funny. One of the commenters, I was reading the other one, he said that my toupee looks good. And I thought to myself, is he serious? Does he really think that I wear a toupee? So I have what's called a widow's peak, like that's for sure. But I haven't heard that one before. It's one of the most clever things Rob's toupee is really on tight tonight. What? Which is just funny. It's okay, whatever, man. If that's whatever you want to do. I like creativity. Let's see here. Isaac Bowles says, I love you, Rob, but I'm celebrating Garrett Rolfe's charges were rightfully dropped. Oh, gosh, Isaac Bowles. Lean says, no, Rob, I've been defending your good name all this time for nothing. Well, I don't know I don't know. It's a dynamic world, Lean. I'm a fluid man. Things are changing. It's 2022. We're transitioning here. We're just transitioning to a volatile, violent chat, I guess. Bruce Leroy says Trump didn't run the Justice Department. Nunez filed 8+ criminal referrals in 2019 and Barr ignored them. Yeah, well, that's because Trump sort of had a mutiny in his entire operation from many people who were in charge over there. So that's a good point there, Bruce Leroy. Yeah, I mean, weren't his intelligence companies or his intelligence deputies hiding stuff from him? Whole thing was ridiculous. All right, now it's time to go over to locals and see what is going on over there with Georgia Peaches and others. As you can see, Georgia Peaches says, hello, everyone. Kenny Cole says, Lego, and terrific Tuesday to you, Rob, and to the watchers. Comes in from TOS Forever. We've got a former LEO in the house. He says, Rob, I was wondering, why didn't they mention the leaking of the sealed warrant affidavit in an effort to circumvent the law? The information leaked was designed to swing public opinion away from Trump to support the government's lack of a case. I agree with that. Yeah, I mean, they wanted to have it both ways. They wanted to claim the DOJ's independence and integrity while also leaking damaging information. Says that should have been the number one reason to unseal to prevent the additional abuse by the government. Maybe an order by the court to stop the leaking of additional information to the public. The only reason to leak is to prejudice them against the former president, who happens to be the defendant. I think it should have been included in their motion to unseal. That's an interesting point. Yeah, they didn't really, you're right. They didn't really, well, they did kind of bring that up, actually. They did bring up the point about, a lot of this stuff has already been leaked, essentially. And so what's the point of maintaining the secrecy of the documents if we already know what's in it? And here is another one that came in from Jason on Blast. He says, what this administration gets away with is truly nauseating. That's true. Says here, Rob, would you do the big, beautiful spotlight on the show today? Us old timers are missing it. I need my fix. And 3 girlies, shout out to the youngest girlie, says, I second that motion. We can try it. I mean, Bonnie, we can try it at the end of the program, I guess. But it's been a long time. I don't even know if I know what it is anymore. We'll have to see. Sausen says, hi, I made it. Got to get my Watching the Watchers fix. We're glad that you're here, Sausen. Good to see you. And let's do a refresh before we jump on into the next page on this thing. And we're waiting for the screens to load fresh. 3 girlies is in the house, says, I have created a youngest girly monster. She is now insisting I comment so she gets a shout out. I told her you shouted her out 3 times last night and she made me rewind each one of them. LOL. So, okay, yeah. So shout out to the youngest girlie. I mean, I got unlimited shout outs for the youngest girlie, so no problems there at all. She also asked if you knew she starts school tomorrow. I told her yes. She says, well, now I can't watch the walk and talks because I'm going to be at school. Ugh! I told her that she can watch it when she gets home. Yes, school, it gets in the way. But school is very important. School comes first, always does. Got to educate yourself. And then after the education is over and after the homework is done and the chores are finished, then we can get on little YouTube and, check out some shows. But it is funny, three girlies and the youngest girlie, shout out to Heather and the whole family over there. And school's starting up and yes, fun times. A lot of kids going back to school. One Florida man says, hello, everybody. Tricky says, hello. One Florida man says, big day. Florida election polls, they just closed at 7 p.m. We're going to get an idea of what direction the state is moving in after all the millions of COVID refugees migrated to Florida. A lot of that going on. Robute says, how is Biden meant to know that he was for rating Donald Trump? Remember, he doesn't even know where he is half the time. Yeah, I don't know. That's a good point. Yeah, he probably doesn't remember or doesn't know. Martin is here. He says, a deranged anti-Trumper, Bill Maher, had patriotic Trump voter Rob Schneider on his podcast 2 days ago. And holy moly, Maher is full of it. Bill believes the Russia collusion. He absolutely is irrational about Trump should go to jail narrative. He really did drink the California Kool-Aid. There's no saving him, just like Harris. Trump University was a no-no, and I don't care how many times Hunter gave other Democrat ex-president daughters monkeypox. How dare the Cheeto Hitler sell people steaks and water? It's a good point there, Martin. And it's a lot of that is going on. You start asking yourselves, how do these intelligent people just lose themselves so thoroughly to a politician? I don't know. Miss Lucky and Sergeant Bob say the Biden administration continues to make the USA a laughingstock of the free world. I hope this continues to blow up in the face of Sleepy Joe. He makes Richard Nixon look like a choir boy. Three Girlies is here. Shout out to the youngest girlie. Says, is executive privilege, and if a current president can revoke executive privilege for a past president going to be challenged in court? In other words, is Trump going to sue or try to stop that? And I think he has. And I think I think he already fought that and he lost that one. It seems a lot of this is hinging on Joe Biden revoking Trump's privilege. And I'm not sure if this has ever been challenged because it's never happened before. I think it has been challenged. I think that there was a whole series of cases that litigated this issue. We didn't talk about it at the time because it was sort of inconsequential, right? You're sitting there asking yourself about who cares about these records? We didn't know that they were going to be raiding his home in Mar-a-Lago because it's unprecedented and never happened before. Robute says, heard that Rasmussen created a survey asking people if the FBI and Joe Biden is using them as their personal Gestapo. He said, yeah, 53% of us likely voters found that FBI is in fact doing that. Personally, state the FBI is the deep state's personal Gestapo as Joe Biden is just a demented puppet. That comes from Robute. This came in from Vientikis, says, so Conan the librarian is coming after Trump. That's basically what's happening here, except her name is Deborah, right? She's a lot less muscular than Conan. So thank you, V, for that one. Here's another one that came in from C. Reed, says the book burning info wars begin. Alex Jones was right. Next up is David Icke. Gulp. Yeah, he's the reptilian guy, isn't he? Here, this one says, hey, friends, listen, I know the world is scary right now, but it's going to get way worse. So buckle up, buddy boy. So thank you for that. That came in from C. Reed in the house. Thunder 7 says, Biden wants his swampy hands on the note Trump left for Beijing Biden when he said in caps, you know I won, Joe. Probably wants to drop chocolate ice cream on it so it's illegible. Thunder 7 says, but seriously, Rob, I'm well prepared for when they indict or arrest Trump. We know what's coming. The Dems are in full-blown panic mode as the November elections loom and their numbers sink lower and lower. When an animal is cornered, they lash out and are irrational. Luckily, the public see this for the political prosecution it is, and it's only making Trump more popular than ever. Here, Tex1 says, I learned a lot this show. Great breakdown and analysis. Well, it's good to see you, Tex. Thanks for being over on our community. Sergeant Bob says, Trump needed, now more than ever. Robute says, does anyone really believe this political hack of a judge will release the fully redacted affidavits unredacted? No. He signed off on an overbroad warrant, and it's been shown through his Facebook post that he hates Trump. He's only denying the FBI attempts to fully unseal the affidavit because he does not want to be perceived as a political hack. He will try to selectively redact the affidavit. Yeah, I think so. I think that's going to happen, or it's not going to be fully unredacted, no doubt. Miss Lucky says 2/3 through betrayal by Robert Fitzpatrick deals with Boston FBI corruption regarding Whitney Bulger, one of the nastiest pieces of criminal. The way the FBI worked is to ignore criminal acts, including but not limited to murder. Covering up is disgusting. The culture, which in my opinion continues to exist. The credo is, no matter what, do not embarrass the Bureau. Another must-read book about the FBI. I would think that these days, FBI agents who believe in freedom would be very hesitant to stay where they are employed. Good to see you, Sergeant. 3 Girly says, Rob, do you think that if Trump had been asserting the affidavit to be unsealed, the result would be any different? Is this because this is all the media versus Trump? Do you think that if Trump had been the one to ask for it to be unsealed, that there would be any more information provided? I think his lawyers did the strategic step of just allowing the media to fight the motion to unseal the affidavit versus them doing the work. I'm not sure how much that's a benefit. Yeah, I think that you're right about that, 3 Girlies. I think that Trump didn't really necessarily need to get involved in this particular suit. I mean, he could have, but, remember what we're talking about here. I think that Trump is playing 2 battles. One is the legal battle. And honestly, that is only so important because unless there's like serious criminal charges, which I really doubt. But if he's playing the legal battle and, what's really at stake there, I don't know. Nobody really knows. He probably knows, he probably has an idea of it because it's his conduct. We don't. But they're playing around with that. With you have to sort of the other battlefield is not just the legal field, it's the political field. And so he's sort of weighing and playing on both fields, and they don't always necessarily work out in cahoots with one another. In other words, being highly political doesn't translate, and being successful in the political realm doesn't translate into the courts. And so I think it's hard to see. It's a little too early to see if it's a good strategy or not. But the media is making a lot of the same arguments that Trump would be making. And so I don't think he necessarily needs to be the stand-in for that. They can do it. And because the presumption is on the disclosure side, we may see more. And I'm not sure that if Trump made his position known that it would have changed the outcome one way or the other. Good question. Cassandra's Go says, judge is covering for himself. He signed a general warrant for unacceptable reasons based on information that doesn't reach the burden under scrutiny attained from illicit means. That's my working theory. So in other words, I think, Cassandra, you're saying that the judge maybe got a little bit over his skis and he's sort of trying to unring the bell, so to speak. Authorized it. Now, maybe I shouldn't let it all out because people will see how bad it is. JC, the Music Man, says, I keep hearing a lot of, quote, unprecedented investigation into a former president. However, there is much precedent established of investigating this president, and the outcome of every one of those prior investigations have concluded that he is the most investigated and found to be squeaky clean presidents in the world of history. No other political figure has been kept at the forefront of people's minds for this long. Trump opponents have fully vetted him and can come to no other conclusion than Trump to be the best person for the job. It's a great point, Jeremy. It's like, yeah, they've unturned and turned over every stinking stone that they could. Here, Bannon is a prophet, comes from Thunder 7. Martin says, will Cheney take votes from Trump? Well, considering 2 years ago in her GOP primary total number of Repubs who voted for her was 105, while the total number of Republicans who voted against Cheney in 2022 is 113. So I say no. Facts Matter says, I advocate for free speech chat without profanity or threats. I like that. Yeah, we in the chat need to ignore the trolls. Feeding them brings them back. Don't be a binger and don't feed the bingers. What did he say? Don't you get brazen with me. That's right. Miss Lucky says, profanity is used when an individual does not have adequate command of the language or, for example, ignorance. I appreciate the grown-up conversations without the crude language. Can we avoid totally abandoning good manners? Yeah, I think we should have good manners, right? I think we should be friendly. We should all be friends in our chat. All of us. Every one of us should be friends. Martin says, letting a polite Canuck make the rules for America? What's next? You're going to start shaping those eyebrows and getting Brazilian waxes, Missy? From Martin. Says, the judge hates Trump, but he's never met a child that he didn't love. That is from Martin. Okay, so okay. It took me a minute to see where you're going with that. But that, my friends, I think is it for us. We had a couple super chats come in. One came in from Gen X Boomer over on YouTube. Shout out to Gen X Boomer, and I appreciate that one. And apparently the chat never started up over on Rumble, and I got to look into that one. So, some things work, some things don't. But that, my friends, is it for us for the day. And so we are going to wrap it up right there. I want to thank everybody who was a part of the program, in particular our very special members over at watchingthewatchers.locals.com. We have Phantasmagloria's over there, Zach Nichols, JC the Music Man, Susanna H777 is in the house, Look2G, Jumpin' Jeff, Wild Child. Yeah. Zach says our chat is friendly over here. Locals is very friendly. It's like a great dinner table conversation happening over in that chat room with, a lot of pictures even being shared. Good stuff. Look2G's in the house, Wild Child, and others. Shout out to our YouTube members who are in the YouTube chat. And big thank you to Paul Minot, who actually donated several memberships today. I think 20 of them. Very generous of him. Shout outs to Jonathan Conklin, Jenny B, Miss Jamie in the house, Carrie Mache are all members. Shane Souza's in the house. Of course, appreciate all of you. I am also a lawyer at the R&R Law Group. We're a criminal defense law firm. That's all we do. We don't touch family law or personal injury cases, none of that stuff. We offer free case evaluations to good people who have been charged with crimes, want to help people and their families get through difficult situations. And we're passionate about the work that we do. We offer free case evaluations. Our mission is to help good people find safety, clarity, and hope in their cases, and beyond that, in their lives. We'd very much appreciate your referrals over to us, 480-787-0394. We offer free case evaluations, and we really appreciate your referrals. They keep us busy, and they keep us doing the work that we're passionate about. Thank you to the mods and everybody in the house who's holding the fort down for us. I'll post a link. Maybe I'll post a poll or something on locals, and we'll work it out with YouTube members and the members, and we'll get your input on what to do about the chat. I'll talk to Viva. I'll talk to Nick and some other guys. But shout outs to Vientikis, to K Bean, to Just Cows in the house. Shout out to our friend Lean and to Playin' Hooky, who are all modding down the fort for us. Final shout outs to our Spotlight supporters. Chris Romero's in the house, along with David B3, Dr. EMB are all Spotlight supporters, which means they just contribute a little bit more. And so we share some screen real estate with them just so that we can all sort of, support one another. And I'm very grateful for their work. But that, my friends, is it for the show for the day. And I want to see you right back here tomorrow so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Have a great night, my friends. I'll see you all tomorrow. Bye-bye.